Let's now get to this breaking news story. SABC News has reliably learned that former ANC President Jacob Zuma, and now leader of the MK party, is expected to be hauled before a disciplinary hearing on Tuesday, the 7th of May 2024. This is revealed in a notice that was set down document by the ANC's National Disciplinary Committee, the NDC. In the notice dated 24 April 2024, Zuma is informed that he is facing 2 counts. The first one is that he contravened the ANC's constitution when on the 16th of December 2023, he publicly endorsed the newly formed Concourt party, the MK party. And secondly, he contravened the ANC constitution when he appeared on the candidate list of the MK party. Now, Zuma may be represented by any member of the ANC in good standing at the hearing. Let's now bring in a legal analyst, Mpumelelo Zikalala. Of course, we want him to weigh in on the current court processes around the IEC and the MK party. But Mpumelelo, thank you so much for your time. But perhaps I'm wondering if you can weigh in on this particular breaking news story and how this matter possibly playing itself out, of course, on an election month will further impact on Zuma's other court processes with the IEC that's before the courts.
Good afternoon to you and also to your viewers. I think it was a long time coming. The ANC ought to have acted and that alleged transgression a long time ago. You can't have a former leader who's going to go out and publicly not endorse you, especially during these critical times when you're trying to view voters to vote for you. So I think it was about time in which they were going to remind the former president and say to him, either you resign as being a member of the ANC, if you're not going to do that, then we're going to assist you by bringing you in front of the disciplinary process. You know what the constitution is. You've been at the helm of this party. You know exactly what the rules are. If you look at your rule 4 and your rule 5, they clearly state what the duties are and the oath that you have taken. If you break that oath by making or by joining other parties or publicly endorsing them, then you've broken the ultimate rule of the ANC constitution. Hence, you must come and account. If we don't do so, we'll proceed with the disciplinary process, and the end results will be an expulsion from the ANC.
And I mean, what are the likely then implications, if any, in as far as these matters are concerned? Because I mean, we're so close to this very crucial election, and yet you are seeing these court cases playing, out in the IEC and the MK matter, particularly as we know that the IEC has its deadline today, in as far as that matter, to furnish the Concourt with pertinent documents.
I think there are a few ways of looking at it. Firstly, from the side of the ANC, they are saying we're going to stamp our ground with it. We are an entity that has to install discipline. So whether you're a former president or not, the ANC constitution remains the same. And if you don't subscribe to the rules, we are going to punish you. From the side of the former president, he may want to fight it. While he's fighting that, remember there's an election campaign that he needs to do for his other party, which is MK. There are also other legal proceedings which are taking place. And they're certainly going to take a toll on his time, which is allocated to him, and maybe his ailing health, if the reports that are being stated are indeed actually true. So it may be a situation where the ancestor is trying to stamp his ground, and he's going to have a lot more to deal with in his plate. From the side of the IEC and the other processes that are currently going to take place within the Constitutional Court, I think that one has to proceed as an important precedent-setting type of cases that needs to be dealt with as soon as possible, so that we have clarity to say what exactly is the meaning of Section 47 of our Constitution. How should we interpret that particular clause in the future elections which are going to come? This is not the last election that we are going to have. Certainly, there's not a lot is going to happen between now and the next elections. So the IEC needs clarity as to what is true and what is correct. When we had the IEC, the Electoral Court, the other day, they came to one conclusion. However, the reasoning was different from all 3 judges, or three judgments basically. So it's important for the sake of jurisprudence and also for the IEC to know what is correct, what is right, so that if they are faced with a question similar to this one in the near future, they know exactly what to do.
And I mean, to your point, the IEC is then expected to furnish the Concourt with the record indicating how it arrived, at that decision to uphold the objection that saw, the former president being disqualified from appearing on the MK party list in terms of that section that you've mentioned, also 47(1)(e). But also the MK party as well as Zuma are to then file their answering affidavits. How are we likely, to read into that answering affidavit at this point in time?
You see, the first problem which is going to be there's a procedural flaw that took place. A complaint has been made, and before a decision maker makes a decision, they don't go to the person who's been complained about and they say to him, here's an objection that has been filed under your name. Do you have any responses? Procedural fairness already dictates that whatever decision is taken there should be set aside. So I think the Constitutional Court was very intelligence in asking that particular question to say, how did you arrive at this particular conclusion? We want to understand the nature of the process that have been there, despite of what the Electoral Court has stated. But from the side of the former president, he's going to simply come with the same arguments that he came with to the Electoral Court, and maybe just to amplify them in terms of saying, when you issued this remission, Mr. President, you then allowed me to fall within the threshold of the individuals that are able to participate in elections. It cannot be that the issuing of the remission affected how the sentence ought to be served because you have parole that take care of that. In this one, when it comes to remission, you are simply stating whatever amount of time that has been issued by the court has now been reduced by you. And correctly stated in the second judgment of the Electoral Court, you have two things or two tools that you can utilize. Firstly, it's the Constitution and the courts as it lies. And then the other one is the provisions that are contained in the Constitution. Section 2 of the Constitution is clear. The Constitution is the supreme law of our country. That means anything else other than the Constitution or that is in contravention of such cannot survive. And the Constitution will always trump whatever legislative processes that are there. Now, as per legislation, it's obscure as it might sound, the president has powers to issue out those remissions. The president has exercised his power, whether correctly so or not correctly so, but the effect of that is that they must be followed to the T, and the results that we have now is that the sentence was reduced. Hence, if we want to make sure that we stick to the correct side of the law, that particular remission must be upheld.